Good morning.
Good morning.
May it please the court. Judge Higginson, Judge Willett, Judge Ho, good morning. We find ourselves here today addressing an issue, concurrent causation, that this court has demonstrated interest in of late. It recently certified a concurrent causation question, albeit in a different context, to the Texas Supreme Court in the Dillon Gage versus Lloyd's case. And it certified questions that are virtually identical to the questions presented in this case in Freimeyer versus Ohio Security. Fortunately or unfortunately, Freimeyer settled, I think, about 2 days before there was supposed to be oral argument at the Texas Supreme Court.
So have I wasted all of your time as presiding judge making you come? Should we just certify question 3 again?
Judge, I believe that the court can reverse and remand without having to certify questions. If it's necessary, if the court feels it's necessary, we certainly would welcome the Supreme Court's input. But we believe that under existing Supreme Court precedent, that the court is perfectly able to reverse and remand here.
And that's your argument. Go ahead then.
Mr. Overstreet's case gives this court the opportunity to finish what it started in Freimeyer, which actually I think involved the exact same storm as the case that the storm that's is at issue here. It's a June 6, 2016,
you're right.
Or 2018 hailstorm in the Dallas area. I think it's the same storm, which is just kind of interesting as an aside. But by finish what it started, I mean it gives this court the opportunity to look carefully at what the court called the difficult specter of whether the mere presence of any pre-existing damage whatsoever on a roof triggers the application of the concurrent cause rule that was articulated by the Texas Supreme Court in Lyons back in 1993. That rule being, of course, that when covered and non-covered perils combine to cause an injury, the insured must present some evidence that allows the jury an opportunity to a reasonable basis on which to allocate the damage. In Freimeyer, this court pointed to Lyons as the Texas Supreme Court's primary authority on concurrent causation. And it's important to recognize that Lyons, even though it was decided in 1993, was decided under the law as it was pre-1991. And that's important because until 1991, the insured bore the burden of disproving an exclusion to coverage. Of course, in 1991, Section 554.002 was enacted, and that section, which is still there today, established the rule that we follow now and that we've followed since 1991, which is that the insurance company, not the insured, has the burden of proving any exclusion. Now, the facts of Lyons were a little bit different than the facts here. In Lyons, the question was whether the damage to the insured's home was a result of wind or settling of the foundation, which was the excluded peril under the policy. At trial, the insured's expert testified that it was likely that there was pre-existing damage to the home, and he also testified that the determination of storm-related damage would be very hard. Lyons, the insured, and her neighbors also testified at trial that there was no pre-existing damage to the home at the time of the storm. The jury found for the insured and attributed 25% of the damage to the covered cause, the windstorm. The Court of Appeals reversed and remanded because the jury instruction had failed to put the burden on the plaintiff to disprove the exclusion. So at the Supreme Court, the insurer argued that the judgment should be rendered because that expert testimony was insufficient to allow the jury to allocate damages. The Supreme Court didn't really comment on the expert testimony because it didn't have to. The court actually found that Lyons and her neighbor's testimony that there was no damage to her home prior to the storm was sufficient to satisfy her allocation burden, and that was at a jury trial. Here we're at summary judgment. And also recognizing that back then we're under a totally different framework where she, not the insurer, had the burden of proof on that exclusion. And the court emphasized in Lyons—
You've got expert Earl saying it was that storm.
Correct.
Judge McBride said first threshold issue, possibly a sham, hence it cites Dallas versus Independent School District. So we've got to get past that. And you think that's just a flat wrong suggestion?
I do, and actually the exact same, well, not the exact same, but a very similar situation arose in Freimeyer, where the district court had completely disregarded the declaration of the insured's expert, said that it was inconsistent with prior deposition testimony, and refused to consider it at all, and granted the summary judgment, but did not rule on the insurer's motion to strike in light of the ruling on the summary judgment. Right, it's exactly what happened here. And in Freimeyer, that did not stop the Fifth Circuit from considering that declaration, finding that it did not fatally conflict with the prior deposition testimony.
Like here, we've got an expert that does attribute all the damage to the covered storm.
Correct.
But at the same time, it looks like the expert's being honest and saying every roof is an ugly roof.
That's
got
right.
wear and tear, and sure, the Weather Bureau says there are other storms.
That's right.
Isn't that, so why aren't we certifying if a panel of our colleagues said exact same fact scenario, exact same question?
And we're happy for the
I know you're happy, but you started out by saying we don't have to, and I'm still not sure I understand why.
Sure. Well, so let's continue with Supreme Court precedent after Lyons, because we've got to recognize here that there's this whole body of case law that Allstate relies on. The Supreme Court has decided exactly 3 concurrent causation cases in this context since 1993, with the first being Lyons. And again, this is under the old standard. And then the next one was the Utica case in 2004. And in Utica, it was in a third-party context, again, a little bit different factually. But in that case, the Supreme Court reversed the lower court's summary judgment in the insurance company's favor, and said that the Supreme Court said it could not even determine whether the concurrent cause rule applied at all until there had been a determination by the fact finder that there had been some damage attributable to a non-covered cause. So in that case, the court is saying, we can't even look at this until we have a fact finding. And that's in line with what some of the non-binding precedent says, which is, yeah, it's almost always a fact issue, whether causation is almost always a fact issue. Then in the JAW the Point case in 2015, that's the third case that the court decided, and again, factually distinguishable. But the important thing to take away from it is that, again, the court emphasized the importance of the fact finder's determination of causation, not just the mere presence of some existing damage that's necessary in order to invoke the doctrine. And again, the court confirmed that the insurer, while the insurer does have the burden of establishing coverage, that the insurer has the burden of proving an exclusion. No Texas Supreme Court case stands for the proposition that the burden changes when an insurer...
Why are the federal district courts in Texas so mixed up?
Some believe that in 1999, there's a San Antonio Court of Appeals case called Wallace, where the court came up with this language that's been quoted, I think, 18 times or something since then, where they say concurrent causation is not an affirmative defense or an avoidance. Basically, it's an element of coverage. Right. And so there are many who believe, and I mean, your guess is as good as mine, but I mean, we kind of saw the same thing in the context of statutory bad faith in Chapter 541 in Menchaca the Supreme Court came and told us in 2017 and then revised in 2018 that, hey, these lower courts have been doing this for years, and, we never said that. So I think it's just kind of a situation where some intermediate appellate courts kind of took Wallace and a few other cases that developed after Lyons was decided and kind of ran with it, and it's developed into sort of an unattainable standard. I mean, there are a number of reasons that the standard that Allstate seeks to impose don't make sense, and one of them is that it really is almost a completely unattainable standard. This court recognized, and Judge Higginson, you just said a minute ago, every roof's an ugly roof. Every roof, if it's a day old, it's got wear and tear. Every roof shows signs of age. And at least in certain parts of Texas, like where the Overstreets live, every roof is going to weather a hailstorm from time to time. But existing damage does not necessarily equal cause of loss, especially where, like in this case here, the existing damage didn't cause any problems. Mr. Overstreet testified that there were no leaks until after the June 6, 2018 storm. So
Am I right that his expert, when you say my our guess is as good as yours. It's not. You two, this is why we have argument. You two work in this field. You know this case much better. But am I correct that no one was able to point to a penetration through the roof causing interior damage?
Earl, that's correct. Earl he did not identify a storm-created opening. There were parts of the roof that he was unable to get to because of just the configuration of the attic and the home. And that's something that Allstate has argued that, well, if he didn't say that he found a storm-created opening, then there can be no interior damage that's covered.
It's probably the hardest part of this case for you.
It is, but it doesn't change the result because in any event, we've still got the roof is the primary component of the damage. Obviously, Earl's photographs, his report is clear that there was significant roof damage as a result of the June 6, 2018 storm.
So you got us through the trilogy of Supreme Court cases. Where were you going to end up?
Okay, so no Supreme Court case says what Allstate and other insurers argue that the standard is. But nonetheless, that's what some courts have required. And it doesn't make sense for a number of reasons, one of which you just touched on is that I was talking about. It's an unattainable standard. Under the standard that Allstate advocates, if it comes into court at summary judgment and says, well, there were a couple of storms in 2016, which there were. There's a couple of storms every year in that part of Texas. There might have been some damage to the roof, so Mr. Overstreet is just out of luck unless he can account for every hail hit on the roof. And it would be, I believe in Freimeyer, probably the insured, I don't remember which party or if it was amicus, but one of the parties in Freimeyer likened it to an insured's car that gets crushed in a wreck with an 18-wheeler, and the insurance company comes back and says, oh, well, we think you had a door ding, or a scuff on your fender. It's an old car, you've driven it for a long time, and so you're gonna need to have an expert come in and apportion the damage between the door ding or the scuff on your fender and your car that's now an accordion because it's been crushed by an 18-wheeler. And frankly, that might even be doable in the automobile context, but it's certainly not doable in the context of roof damage, because unless you've got somebody going up on your roof and inspecting your roof and taking photographs and documenting individual hail hits every time there's a storm, there's no way that Allstate is ever going to be satisfied with.
That's still on the unattainability, but you said there were multiple reasons.
Correct. There are other reasons. One is, in this case, Allstate's adjuster found $1,300 thereabouts of covered storm damage, right? Our expert says it's more like $55,000, but Allstate's adjuster did find some damage at his initial inspection. No payment was issued because it was under deductible, but he did find some damage. Let's say that instead the adjuster had found no damage, said there's no hail damage to this roof at all, this is all wear and tear, these are nail pops, lack of maintenance, whatever that's not covered under the policy. If that's what Allstate's adjuster says, then we go to trial and we have the burden to prove coverage, and Allstate has the burden to prove that exclusion, right? It's one or the other. Why should it be any different when Allstate acknowledges, okay, there's a little bit of storm damage, $1,300 worth of storm damage. We're not going to pay for it because it's under deductible, but we think it's covered by these other things. Why should it be any different? Why should the burden on the application of the exclusion or the burden on disproving coverage, why should that be on the insured in that context when it wouldn't be on the insured? It's clear under the statute and under clear precedent if Allstate had simply denied the claim and said that there's no damage at all.
I'm curious, did you read the briefs and listen to the argument in Freimeyer?
I did read the briefs. There was no.
Did both parties agree it should be certified?
I don't know, Judge.
Because in this case, neither of you are urging Freimeyer question 3 be certified, but I'm wondering if that panel did it because both parties said do it. Who knows?
And I don't know the answer to that question. I did read the briefing in the Supreme Court, but I did not listen to the oral argument at this court. A third reason that it doesn't make sense.
Right, they did brief it. Yeah, okay. Yeah, that's right. Yeah. Then it's settled. Okay.
A third reason that it doesn't make sense is that it makes a replacement cost value policy, which is what Mr. Overstreet had, it makes it completely illusory. He has a replacement cost policy. He pays a higher premium so that if his roof needs to be replaced, he is paid for the actual replacement cost as opposed to the actual cash value, which is, of course, the replacement cost less depreciation. So what's depreciation? Allstate's own training manuals, claims handling manuals, say that depreciation is a decrease in value of an item or property over time due to age, use, and condition. So if the effects of age and use, meaning wear and tear, basically, aren't covered under the policy, then RCV coverage is totally illusory. And we also talked in our brief about the Office of, I can't remember what the stands for, it's OPIC, something Public Insurance Counsel, basically a consumers' rights organization established by the state of Texas, right on their website that they have for consumers. I see that my time's up. On their website that they have there for Texas consumers to look at, it says, if you have an RCV policy, your insurance company will not take into consideration things like wear and tear, age, I don't remember what the exact words are, we have it in our brief. If you have an ACV policy, they will deduct for those things.
Thank you very
Thank you.
much. If you have rebuttal time. And we get to hear from Mr. Harrell. Do you know if both parties in Freymire wanted?
Sorry, Your Honor?
Do you know if both parties in Freymire wanted to certify?
I don't, Your Honor. I don't know the answer to that question. I'm sorry. Your Honors, and if it please the court, there's no dispute that in insurance coverage and bad faith cases, the plaintiff bears the burden of proof on the issue of coverage. With that in mind, the district court's summary judgment in this case should be affirmed because, as to the alleged interior damages, Mr. Overstreet produced no evidence that an opening in the building envelope created by the June 6, 2018 storm at issue caused any interior damages. And under his insurance policy, such an opening was a prerequisite to there being any coverage for interior damages. But Mr. Overstreet's expert witness, Mr. Earl, found no storm-created opening, and he could not trace the source of any of the alleged interior damages. As to the roof, Mr. Overstreet did not meet his burden, to provide evidence allocating the portion of the loss caused solely by the June 6, 2018 storm. Now, as this court held in Hamilton Properties, when the evidence merely shows the current damage to the property can be linked to the storm at issue, but does nothing to enable a jury to segregate damages for only that property damage caused by covered perils that occurred within the policy period, then the failure to comply with the concurrent causation doctrine is fatal to the plaintiff's claim. And that's what happened here. Whereas here, there is competent summary judgment evidence of other causes of loss, the plaintiff's segregation burden in the summary judgment context is triggered. Both parties cite to the generation trade case for that proposition, Your Honor. And the plaintiff can satisfy that burden in one of two ways. First, he can dispute that other causes contributed to the loss, and he can provide evidence that the particular storm at issue was the sole cause of the loss, essentially a sole causation theory. Alternatively,
Earl did say it was all caused by June 6.
Mr. Earl testified that he focused on 1.25 inch hail because that's what he associated with the date of loss storm, the alleged date of loss storm, based on his weather data. But he also testified that he saw other hail damage on the roof that he did not associate with the June 6, 2018 storm. And he testified that based on his own weather data that he relied upon, that there were storms before the policy period incepted and after the policy period ended that produced 3/4 inch hail, which he testified was strong enough to damage this particular type of roof. I believe
That would be good fodder for cross-examination as to why he says it was all caused by the covered storm. But I don't quite understand, Judge McBride, was he somehow invalidating all the testimony on the notion that he's just sort of unsaid what he said before?
No, Your Honor.
Put aside sham affidavit doctrine.
Sure, understood.
You agree?
I'm sorry?
Do you agree we should not discard expert Earl's testimony because somehow he'd contradicted himself?
I believe his deposition testimony was admissible, but not his affidavit, Your Honor.
Okay, well, explore that a little bit.
Well, Judge McBride first off, let me back up and say that Allstate filed objections to the declaration on the basis that it was inconsistent with the deposition testimony. Plaintiffs did not respond to those objections. Judge McBride made a specific finding in his opinion that, I'm sorry, I've lost my place.
Well, he cites Dallas Independent School.
Yes, you're right, Your Honor, I apologize.
Do you think he discarded what Earl said entirely because it was an effort to create a fact issue by denying what he'd said before?
Yes, Your Honor, I found it here. It's at 2021 WL1238299 at star 3. The court made a specific finding that, quote, the declaration is inconsistent with the expert's deposition testimony, thus it cannot be used to create a fact issue to defeat defendant's motion. I, frankly, Your Honor, don't know why he said in a footnote, I'm not going to rule on these objections. I'm going to give the summary judgment evidence the effect it deserves, because functionally, he did grant the objection, because that's almost verbatim from the objection to what the basis for it was. And he said it cannot be used to create a fact issue. He set it aside entirely. This is actually...
What's your closest case? Because I find that to be a real stretch, so I'm just being candid with you. What's your closest case that we've announced that would mean it's a sham affidavit? In other words, I don't see him sort of contradicting what he said before. I just see him acknowledging there was bad weather in the area.
And Earl acknowledging
yeah,
that.
he's acknowledging something you could cross-examine him for, but I don't see this would fit in any of our prior law that therefore there's no evidence at all that can be accepted from it because it's a sham.
Well, first off, I would say it's problematic for the plaintiffs because that finding is in the opinion. They didn't...
No, I'm asking you for your best authority from our court that his affidavit is a sham affidavit, shouldn't be considered at all, supporting what I think you're making, that argument.
Well, I don't have a specific sham affidavit case to cite to you, Your Honor, but I would say that in his declaration, he makes this statement that 100% of the losses are more likely than not caused by the June 6, 2018 storm at issue. In his deposition, at least with respect to the interior damages, he says, quote, I don't know, that he was just giving the insured the benefit of the doubt, in his words.
Assume that the evidence is there, as it appears that Judge McBride did. So then are we just in the Freimeyer question 3 we should certify, or are you not pressing certification either?
I'm not pressing certification either, Your Honor, but I would also say that there's a distinction between what happened with the alleged sham affidavit in Freimeyer and the declaration here. In Freimeyer, Judge Boyle at the district court level said, I've got this objection that it's a sham affidavit, but assuming its admissibility, it still doesn't raise an issue. Here, Judge McBride did the opposite. He said, I'm giving the evidence the weight it deserves, and this evidence deserves no weight whatsoever, and I'm not considering it because it cannot be used to create a fact issue. By any definition, Your Honor, that is an evidentiary finding about that declaration, and it was not challenged.
Without supporting authority, I find that difficult, so I'm asking you to assume that it is an evidence. Go ahead.
Okay. Even if it were an evidence, Your Honor, I would say that there's a bigger problem here, which is the one that this court addressed in Hamilton Properties. In that case, like here, there was evidence of hailstorms that occurred outside the policy period, but the district court held that the plaintiff had not met its segregation burden because it had not accounted for that existing damage from the other hailstorms. And this court affirmed that. And that makes sense, Your Honor, especially in this context where we have an expert on the roof saying, I see hail damage that I do not associate with this storm, but I'm not going to account for it at all. I'm just going to ignore it. How could you ever meet your segregation burden in that context? Because how could you ever say that the damage that you're just completely ignoring didn't contribute to the structural integrity issues with the roof? You can't. It's no evidence because he did not consider those other damages.
How is this different than the predicament the Freimeyer panel was in? Besides your argument about Earl's being a sham.
Right. I believe in Freimeyer the issue was wear and tear and not hailstorms outside the policy period.
That's the difference?
And there was no evidence suggesting that the roof was damaged solely by the cover. The plaintiff had produced evidence suggesting that the roof damage was caused solely by the covered hailstorm. Here that's not the case because Mr. Earl testified there is other hail damage to this roof that I am looking at that I cannot associate with this storm. That didn't happen in Freimeyer. If a roof exhibits pre-existing damage, the plaintiff doesn't meet his segregation burden by ignoring it. You take it into account and you either say, look, this pre-existing damage has nothing to do with this loss. It is, this is a sole causation issue, or you take it into account and you segregate it. Neither happened here, and that's the big problem. There's an opinion I cited from a magistrate judge, Judge Matthey in the Western District, that said it very colorfully, but I think very accurately. And the expert in that case testified very similarly. He said, I basically segregated because I ignored everything else. And Judge Matthey said, you can't satisfy your segregation burden by burying your head in the sand as to the non-covered causes of loss. You have to consider them, and you have to account for them. It's sort of like the Wallace case that Ms. Wray referenced. That case was a foundation damage case. And the issue was whether or not plumbing leaks, which would have been a covered cause of loss, caused the foundation damage that the property exhibited. In his deposition, the expert was asked about several other potential causes of foundation damage. I can't remember them all, Your Honor. I think it was 6 or 7 different causes. And on each one of them, he said, sure, that could have been a cause. Sure, that could have been a cause. Basically, anything's possible type testimony. But ultimately, he said the foundation repairs need to be done because of the plumbing leaks. And no one could allocate. It would be impossible to allocate as to any of these other causes that could have contributed. And the district court granted a judgment notwithstanding JNOV in that case because they had not met the segregation burden. And the Supreme Court ultimately found that that was the correct decision because ultimately the jury's verdict that 35% of the damages were attributable to the covered cause of loss could not be affirmed because the plaintiff's own expert had said, I can't allocate the damage.
But isn't that consistent? Isn't that what she's asking for? Give us a chance in front of the jury to allocate?
Well, again, the Supreme Court found if the Court of Appeals Wallace was the San Antonio Court of Appeals, ultimately found that a JNOV was correct because you couldn't meet the burden, what would be the point of putting that to the jury? They're essentially talking about it as a matter of law based on the evidence that was presented by the expert who said, I can't segregate. It's functionally no different than here where the expert is saying, I see other hail damage. I do not associate it with the date of loss storm.
Has the Supreme Court ever affirmed a summary judgment in a concurrent cause case?
Not that I'm aware of, Your Honor. I don't know if they've been presented with one, quite frankly. I'm not aware of any opinions on one.
But here we should.
Yes, Your Honor. This court has in the past. It had in Lowen Valley, which Your Honor authored. It had in Hamilton Properties in 2014.
Why? I'm going to ask the same question I asked her. Why are the federal district courts so in disagreement? You probably know all the cases. Judge Hainan's case, Lambertet?
Yes, Your Honor. I actually don't think they're in disagreement. I was looking at all of the cases that the plaintiff had cited, and as to the unattainability argument, the very cases they've cited show that the unattainability argument holds no merit because other plaintiffs have overcome summary judgment, but they're doing it in a context of it's an all-or-nothing proposition. 100% of the damages were caused solely by the date of loss storm. There's none of this, I see other damages up here that I'm just going to ignore. That doesn't...
It does say, in my expert opinion, this was caused by June 6th. Why isn't that exactly like Nasty, Cantu, Presswood, all those cases?
Because in none of those cases did the expert testify, I actually see other hail damage on the roof that I don't associate with the storm that I'm going to completely ignore and not consider.
He gets up on the roof, he takes photos, he says, this is a 2-year-old roof. It's an ugly roof. It's had wear and tear. That's almost judicially noticeable. There was another storm. All those cases ended summary judgment, unless he can say, well, this was caused by this hailstorm, and this little dent here was caused by this hailstorm.
I don't know that it has to be that granular, Your Honor, but certainly he has to at least, if he sees other damage that contributes to that could impact the structural integrity of the roof, and don't forget, he testified specifically that the size of hail associated with those other storms could damage that roof. If he sees that and he says...
Down here, because I want to focus on this point.
Yes, Your Honor.
Are you talking about the testimony at ROA 1407?
I believe it was between 1405 and 1409, so you're probably correct, Your Honor.
Okay, so just to be clear, Earl's asked, so just to make sure I understand, there was damage you observed that you thought was from other dates of loss, but it was different in size, so you didn't mark that. And the answer is yes, that is correct.
I believe, Your Honor, I don't have the whole... There's another comment, I think a page or two after that, where he specifically asked that he didn't account for the damage from other storms, and he says that's right.
Yeah, that's where I am. That's
okay.
Correct. I tried to focus on the hail that I could correlate to June 6th. And the point is, the underlying in the question is, you didn't mark the ones that were smaller.
Yeah.
Is that your point, that he essentially only focused on the bigger hail and just didn't count the ones?
Yeah, Your Honor, I think that's generally correct. I do think there's one more comment, and I'm happy to follow up.
No, there is. At the very next page is, okay, the question is, as far as the smaller hail, this is the question, as far as the smaller hail damage that you observed, you wouldn't have been able to tie that smaller damage with any particular day of loss since there's so many with that size. Answer, yeah, it could have been any of those dates of loss.
That's right, Your Honor.
I just want to make sure this is the passage you're referring to.
Yes, Your Honor.
So if I understand it, I'm going to ask opposing counsel the same thing. I take it your understanding of this is it's an admission that there was big hail damage, there was smaller hail damage. He's only focusing on the big hail. There's a lot of smaller hail damage that he's simply going to...
I think that's what he's trying to testify, Your Honor. As pointed out in our brief, there's also a problem with the consistency between what he's saying and the data on which he's relying as well. But yes, Your Honor, generally speaking,
You're saying this is an admission.
yes.
This is saying, like, I'm normally looking at the small, at the big.
I'm not going
looking at the small, but there is some small. In fact, there's quite a bit of small.
Right. And Your Honor, what's really interesting is if you look, I think, a page or two before that in the record, maybe in the 1405 to 1407 range, he makes a comment that ordinarily he does consider all the hail damage. He does mark hail damage that he doesn't associate with the storm, the date of lost storm. He also marks things like mechanical issues. He refers specifically to heat blisters, which can be a sign of a manufacturing defect or improper ventilation of the roof. He just didn't do it in this case. That's what's different here. It's just like in Hamilton Properties. You can't ignore the other causes of loss that could have contributed and say, that's my segregation.
So what's the property owner supposed to do? After each storm, go up and confirm what damages comes from each?
I don't think the property owner has to do that, but I think an expert can, a competent expert can do, a cause and origin expert can go on the roof.
Distinguish between hail, dents?
Yes, yes, Your Honor. I absolutely believe that a competent expert, and they do, look at hail damage and can associate it with this is old, this is new, this is this size, this is that size, and he can say, well, this much of it was 3/4 inch hail. If, again, this assumes that we
Why
overlook
didn't he do that here? That's what I'm confused. Was this just a,
I don't know, Your
I
Honor.
hesitate to say this, but just kind of incompetence on the expert's part, or? I'm not making that accusation. I'm just trying to, like, it seems like he can do it. He just chose not to.
Yeah, it's a strong word, Your Honor. I'll say it's Your Honor's word and not mine, but certainly.
It's not my word either.
Okay, understood, Your Honor.
This is new to me. I'm just trying to understand this.
Sure, but I think your point is well taken, Your Honor. He does testify, for whatever you want to call it, he does testify.
He's able to say, yes, there's small damage, small hail damage, as well as large hail damage. I'm just looking at the large,
That is,
which suggests that he's able to segregate.
that's right.
He's just not counting the small.
Not
for
doing
some
it.
reason.
And again, I mean, I could talk about the inconsistencies between that and his data, as was addressed in our brief, which is similar to the issue the court confronted in Lowen Valley. But at the same time, the ultimate problem here, the big problem, is that he just ignores those other damages. You cannot bury your head in the sand as to non-covered causes of loss and then make a sole causation argument. It was exactly what Judge Matthew, I mentioned a moment ago, addressed in the Sherrybrook case that's cited in the brief.
Same as to wear and tear? Experts got to say, I exclude this because it's wear and tear?
Yeah, I would say a couple of things on that, Your Honor. First off, I want to emphasize that there is a difference here between what happens during claims handling and what happens in the context of a lawsuit wherein the plaintiff has alleged that what you did in claims handling was wrong. There's damages here that were solely caused by this storm, because that's the burden in a coverage case, that you failed to include. Would they have to take into account wear and tear in the context of a lawsuit where they're saying that the insurer got it wrong? Yes, I do think they would have to do that. And this court may be confronted with a case that, as Freimeyer suggested, presents the difficult specter of whether any wear and tear would create such an issue. That may come up again in this court, but that's not this case.
So what happens, though, just putting aside whether it's this case or not, what happens in a fact pattern where the following two things are true? Everybody acknowledges that there were concurrent causes, some of which were covered, some of which were not. That's fact number one. And fact number two is it's impossible to segregate.
I'm sorry?
It's impossible to segregate.
I would say in that
No coverage?
I don't know. I would say that would have to be no coverage, Your Honor, yes. I don't know when that would come up, because
Well,
even
take
here,
take
he's saying
the
he can't.
car ding hypothetical we heard earlier.
I'm sorry, Your
Right. Take the car ding. You know, I forget the exact hypothetical.
Yeah.
The car is crushed, but obviously there are,
Right.
dings.
Right.
And it's just like, I don't know. I don't keep track of what happened to my car.
That's a great point.
No coverage?
It's actually a great point, Your Honor. And there's actually a similar hypothetical posited in the the appellant's reply brief here about what happens when a tornado blows all of the roof off, but it was an old roof, so it had wear and tear. I think you'd have a pretty difficult time in a case like that as an insurer saying that the wear and tear combined with the tornado or the other car running into your car to cause this loss. And I think...
There'd be full coverage.
I'm sorry?
There'd be full coverage.
In that context, I think that there would, Your Honor. I mean, imagine, the wear and tear has nothing to do with the car hitting you. The wear and tear on a roof, by way of the analogy provided in the appellant's reply brief, has nothing to do with the tornado pulling the roof off of it. They didn't combine, which is the language used by the Texas Supreme Court and Texas appellate courts, to cause the loss.
I take it that's because the smaller ding really has no causal connection to the loss.
Yeah, I don't know if that actually, based on the plaintiff's expert, Mr. Earle's testimony here, I don't think we can say that, because he is adamant that it is generally accepted that 3/4 inch hail can damage this roof, and he saw those other damages.
I'm just trying to segregate these two scenarios.
Sure.
In the scenario where your tornado roof or the car ding, your point is, yes, there might have been wear and tear, but it has nothing to do with the loss. We can ignore that. This is a sole causation case.
Yes.
This case you're saying is different.
This case is...
It's a concurrent, multiple damages attributable to both, or damages attributable to one, damages attributable to the other. You acknowledge that you can segregate, you just didn't.
I think that's generally correct, Your Honor. I'm happy to yield back the rest of my time if the panel has no other questions.
Thank you very much, Counsel.
Thank you, Your Honors. Oh.
Counsel, can you help me understand this testimony that we've been talking about, 1407, 1408?
Yes, this is where Mr. Earl was testifying in his deposition about the other storms, which reflected 3/4 inch hail. I believe he testified that 3/4 inch hail could cause damage, but he also testified importantly.
Not just could, did.
And did, but he also testified,
And
though.
it seems to be if he had the capability of distinguishing one from the other. He was just focusing on the big hail.
He was, and the important thing is, though, he said in his deposition also that the damage that he observed that was reflected in his estimate was more consistent with the 1 1/4 inch hail. And again, it kind of all goes together. We have testimony that roof never leaked prior to this storm. I mean, you're going to have any roof that undergoes any kind of hailstorm is going to have some hail hits, right? Does that mean that every time there's a hailstorm, I can call Allstate up and say, okay, come look at my roof, come fix my shingles, I've got some hail damage? I mean, I guarantee you in that scenario that Allstate would say, no, you're not having any problems. This is not affecting the functionality of your roof. It doesn't need to be fixed.
Okay, I'm not sure. Pardon me. You may have answered it. I just missed it.
Sure.
So, what is the answer to the question? He's acknowledging that there's damage from smaller hail. It's essentially acknowledgement that there is a concurrent cause. No?
No, not if that small hail didn't cause the loss at issue, meaning it didn't cause the roof to need to be replaced or repaired. What caused the roof to need to be replaced or repaired?
Are you saying that his damage estimate already excluded the smaller hail damage?
I believe that he testified that he did not. I mean, the damage estimate.
I'd like to know where. Hypothetically, he could have said, look, there's big hail damage, there's small hail damage. I acknowledge the difference. I'm not looking at the small, but my bottom line number is only large. I accept that that's possible. Is that what happened here?
Well, he's calling for a full roof replacement. So whether he included,
that's right. Okay.
It's a full roof replacement. So whether he's calling for, I mean, if we were talking about one slope versus, 2 slopes or 3 slopes, then yeah, you'd get into that.
So you're saying this is the door ding, the car ding hypothesis.
That's
Who
exactly
cares if
what
there
it
was
is.
small hail damage? We're replacing the roof regardless.
That's exactly what it is. He called for replacement of all slopes of the roof.
So that's what. So you theorize this is a sole causation case.
Absolutely. And it sounds like Allstate has a great cross-examination of Mr. Earl, but that's what it should be. It should be a credibility determination. The jury may not like that what he said in his deposition about not considering the other hail damage, but that's for a jury to decide, not for the court.
They brought up legally Hamilton and what's the other one?
Lowen.
Lowen, yes.
The distinction between Hamilton and Lowen, and actually even in this, in Freimeyer, the court acknowledged that it may have put Lowen in the wrong bucket, kind of, sole cause or concurrent cause bucket. But I believe the main distinction is in both of those cases, there was no evidence presented at all to support, to attempt to satisfy the allocation burden. You didn't have the declaration from the expert saying, yes, 100% of the damage reflected in my estimate is attributable to this storm, and a roof replacement is appropriate. The other thing I would add is that Mr. Earl didn't say that every hail hit on the roof was caused by the June 6th storm. He said that the damages reflected in his estimate, and this goes back to what we were talking about, Judge Ho, that the damages reflected in his estimate were necessitated by that June 6, 2018 storm. So I think we're kind of talking about two different things. Allstate's saying, well, he said that all the damage to the roof was caused by this storm. But what he's actually saying is everything that is reflected on my estimate, the repairs that are necessary per my estimate, were caused, I believe, or more likely than not, caused by the June 6th storm.
You have a record cite for the proposition that small hail damage or not, it doesn't matter. We have to replace the whole roof because of the large hail damage.
I could find it if I had it in front of me, but I don't know it off the top of my head. He did say that he can't date hail damage. I've never heard of an expert that can come in. Here we've got two of the prior storms they're talking about were in 2016 within a couple of months of each other. I've never heard of an expert who could come in and say, oh yeah, I can tell you for sure that occurred on June 1st, 2016, and that one right there occurred on July 30th, 2016. I've never seen an expert like that, and I think Allstate...
Maybe not the date, but he's saying, I don't think they're saying you could do the date, but I think they're saying you could do the size of the hail, and that's what your expert is actually agreeing to.
No, and I agree with that, but I understood counsel to say that yes, it would be possible for an expert to date hail damage, and I've not encountered an expert. Now, of course, there's a difference between, an expert can tell fresh hail damage, from hail damage that's been there if it's a 15-year-old roof or something, but that's not what we're talking about here. This is a 2-year-old roof at the time of the storm.
Excellent. The case is submitted. Thank you all. Very helpful. We have final case of the day, 21.